Oops, I forgot my video. I forgot my intro. That's okay. I don't have a microphone. I mean, I don't have a camera this morning. I don't know why it's not working, but it's not. So, there's no camera. It's fine. Now I can scratch things if I want to. It's not a big deal. All right. So, we're going to we're going to do a clip about a dog, but it's not bad. The dog doesn't get hurt. No dog gets injured or anything like that. Actually, is a bad owner an injury to a dog? Yeah. So this dog has a sucky owner, which I don't think a lot of you will agree with. A lot of you are going to agree with the owner. I don't. I don't agree with the owner, but that's fine. I'm looking. It's here. It really is. I had it right here. Here it is. Oh, I gotta share my screen.
You said it. I did. If you did,
I did job about 10 operations as a prosecutor for the second.
thank you. The court recognizes Ms. Laura Odell, also seated next to Mr. Ringstrom, and now seated at the defense
I'm
table is
waving,
the
by the
defendant,
way.
Randy Joe
I'm waving
Raymond,
hard.
or Jolynn Raymond, who is currently in pretrial confinement. We have
Or
Mr.
hardly waving.
Champion in the case. I need Mr.
You don't
Champion.
know because I don't have a camera. CJ, rest. You need to rest, hon.
Can I take just one moment? I'm sorry.
No, I need to go. We're here on Randy Joe Raymond. Mr. Champion is now present. We are behind schedule a little bit. That's okay. We're going to adapt and overcome. We're here for a final pretrial conference and the 2025 file and the 2023 case. We're here for some probation violations. What are we doing?
Your Honor, my client was admitted to the violation.
All right, Miss Raymond, is that correct?
That is correct.
Please raise your right hand. Do you swear or affirm the information testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
You may lower your hand. Ms. Raymond, again, we have two files here today. One is for a final pretrial conference. The other one is here for a probation violation. I'm told by what Mr. Champion said, you're going to admit to the probation violations. Is that correct?
That's correct.
By admitting to these probation violations, you will not have a contested hearing. You'll be waiving the right to have the prosecutor prove the allegations by a preponderance of the evidence. You'll be waiving the right to question or cross-examine any witnesses against you, as well as the right to present witnesses, evidence, or testimony if you chose to do so. This is my reminder. Has anyone made any promises, threats, or inducements to force or compel you to plead guilty to these allegations?
No, Your Honor.
I'm going to remind you real quickly here that there is a series of allegations, and I'm told you were going to plead guilty to all of them, and there are 7.
Your Honor, one of them was already dismissed.
Oh, yes, I see that. That leaves
Blackie or
6.
Chekhov?
The one that was dismissed was a charge of smuggling or bringing contraband into the jail. The other 6 still remain. Those other 6 are one alleges that you tested positive on December 23rd of 2024 for methamphetamine. Count 2 is on that same date. You were found to be in possession of paraphernalia. Count 3 is that you were also found.
Not me. I recorded Fozzie calling me to wake me up, and then I used that as my wake up.
On that date to be in possession of paraphernalia. Count 4 is that you were found to be in possession of additional paraphernalia. This one was a digital scale. One of them was a tourniquet and syringes, and the other one was a smoking pipe. Count 5 was that you were also found in possession of an AR-15 style airsoft rifle. And then count 6 is that you used or possessed controlled substances on or about August. Wait, hold on. Sorry.
How did she get to this point, guys?
Count 6 is that you violated state law when you possessed methamphetamine on December 23rd, 2024. You understand what the allegations are?
Yes, I do.
Has anyone made any promises to inducements before compel you to plead guilty?
No, Your Honor.
You understand that if you waive those rights and I accept your plea, you will not have a trial or a hearing?
That is correct.
And you also understand that you'll be resentenced on your original offense in this case. Yeah, you'll be resentenced. All right, and in this case, you...
So, okay. So I have my own addictions. Everybody has addictions to something. But my addiction, my babysitter gave me cigarettes when I was 9 years old. So, I mean, it was a choice, but it really wasn't a choice. But how does someone choose meth? How does someone, knowing how bad life is going to get, they have to know. I guess they think I can try it once and then it'll be okay. But really, would you look at meth and say, yeah, I can try that once and everything will be okay? How do people in this day and age, when they know all they know, just say, yeah, meth, that's a great idea. I'm gonna do meth. I don't understand.
You were originally sentenced for use of methamphetamine and misdemeanor, up to punishable by up to a year and $1,000. Do you understand?
Yes, I do.
How do you plead?
I plead guilty.
Before the court can accept that plea, I must have you tell me
That
what it
makes
is that you
sense.
did that makes you guilty of
That
that
makes a lot of
offense.
sense.
First, I take
But
notice, or just
you still know that it's gonna end really badly, though.
notice of the terms and conditions for probation that this court issued and signed on or about.
Good morning.
You acknowledged them on October 9th of 2023. Signed them on October 4th, 2023. Is it true, Ms. Raymond, that on December 23rd of this past year, you were found in possession of those items of drug paraphernalia that I mentioned a few moments ago, which included syringes, smoking pipes, tourniquets, and scales?
That is correct.
Is it also true that you tested positive for the use? Please go down. I lost my page. Hold on.
Test positive initially that she did possess.
Yeah, thank you. I'm sorry. Yep, you tested positive for the use of methamphetamine because you previously used some?
That is correct.
All right. And is it also true that you were found to be in possession of methamphetamine on or about that date?
That is correct.
And so I understand that you're also going to plead guilty to the count 1 on the felony information, that the new case?
That is correct.
And is there going to be a dismissal of the second or subsequent?
There is. Yes, Your Honor.
All right, thank you. Mr. Ringstrom, as to the PV, do you believe you provided a factual basis?
I do, Your Honor.
Are you?
See, now an alcohol addiction I can understand because, it's legal. People go out all the time and are not alcoholics and do not ruin their lives, and they drink alcohol. Even people who do it a couple times a week don't ruin their lives and don't become addicted. They could drop it in a second. But, that one point where you see the heroin in front of you, I don't know. No, I'm just going to get more drunk. I'm just going to, there's other things. I'm going to smoke more weed. I'm going to get more drunk. You don't have to do cocaine. Just thinking of shoving something up my nose, there's no way I could do that. The needle for heroin, that I don't have a problem with, but sticking something up my nose, I couldn't do. I just don't get it. I can understand alcohol addiction. even cigarette addiction, because that's legal. It's not like it is now, but it wasn't socially horrible to smoke. It's not socially horrible to have a drink. It's almost expected that you go and drink. Yes, it's a socially acceptable thing. But I don't know. That's what I'm thinking, security. Chocolate. There are other addictions that other people use to get through the bad parts of their life. A shopping addiction, chocolate addiction, um, things like that. The rehab places, maybe they're trying to stop these people from drinking, from doing drugs. Maybe they should, push them into another addiction that'll ruin their life, like shopping. Shopping is a good addiction. Jen, you're doing great. You're doing amazing.
Do you have any other promises, threats, or inducements other than what we're going to talk about regarding the plea as the new charge?
I am not here.
And Mr. Ringstrom, do you believe the court's compliance with court rules?
I do.
Mr. Champion, do you agree with all three?
I do, Your Honor.
The court finds that defendants, based upon freely, knowingly, and voluntarily waived their rights, that the judicial notice of the terms or conditions, as well as the testimony by the defendant, satisfy the required elements of proof. Therefore, the defendant is found guilty of counts 1 through 6 on the requesting warrant for probation violation in file 23-3425. Now, Ms. Raymond, we're going to turn here to the new case. In that particular file, I'm told that you're going to plead guilty. Did I swear her in earlier? I did.
Yes.
I think I thought you. All right. So, ma'am, you understand you're going to tell the truth this time as well?
Yes, I do.
All right. Are you on probation or parole anywhere else?
No.
Are you on bond pending any felony charges anywhere else?
No, Your Honor.
In this other file, I'm told that you're going to plead guilty to count 1. Count 1 is a charge of possession of methamphetamine, a felony punishable by up to 10 years and or up to $15,000. I'm told you're going to plead guilty to that offense, and if the court accepts that plea, the prosecutor will dismiss the sentencing enhancement. The sentencing enhancement is called the second or subsequent drug offender, which could increase that maximum punishment from up to 10 to up to 20 years, and from up to 15 to up to $30,000. But again, that enhancement will be dismissed. Is that what you understood?
Yes, I do understand.
If I enter a plea of guilty, if I accept that plea, you will not have a trial of any kind, and you'll be waiving certain rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose from the court prosecutor, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses, the right to have the court order any witnesses you may have for your defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. Ms. Raymond, do you understand those rights?
Yes, I do, Your Honor.
And do you understand if you plead guilty and I accept that plea, you will be waiving those rights?
Yes, I do.
Additionally, any appeal as to the conviction sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal and not a claim of right to appeal, which is only allowed when you've been convicted at a trial. Additionally, you may be given up the right to appeal issues that would otherwise only be available if you were convicted at a trial. Also, you'll be given up the right to claim that the plea was a result of any promises, threats, or inducements not told to me today on the record, or the plea was not of your own free choice. Are you entering the plea of your own free choice?
Yes, I am, Your Honor.
Have there been any other promises, threats, or inducements that you haven't told me about?
No, sir.
Mr. Champion has probably talked to you in both of these files on what he thinks might happen for sentencing. The question I have is, has anyone told you exactly what the sentence would be?
No, Your Honor.
All right. Anything he has told you about ideas or things are just estimates. Do you understand?
I'm
That's
sorry.
okay. Anything that he's probably told you is probably done well intended, but they're just estimates. Do you understand that?
Yes, I do.
All right. Knowing all that, do you still wish to enter the plea of guilty?
Yes, Your Honor.
As to count 1, possession of methamphetamine. How do you plead?
Guilty.
Before the court can accept your plea, I must have you tell me what it is that you did that makes you guilty of that offense. Turning your attention again to that same date we've already talked about. This seems to be a little bit redundant. Bear with me. On or about December 23rd of 2024 in Lake City, here in Saukey County, were you found to be in possession of methamphetamine?
I was.
And who found it?
Deputy Wetzel.
And where was it located?
In the back of the minivan I was driving, in the wheel well.
Okay.
The tires.
Did you know it was there?
Yes.
And did you have it within your custody and control? Would you agree with that?
I was driving the vehicle, yes.
And did you know that it was methamphetamine? Did you have any lawful reason to possess that methamphetamine?
I did not.
Could you actually, if you were to pick, was it in like a baggie?
Yes.
So you could, if you picked it up, you could see it in there?
Yes.
Sorry, thank you. Mr. Ringstrom?
I agree, Your Honor.
Mr. Ringstrom, you aware of any other promises, threats, or inducements?
I am not, Your Honor.
And Mr. Champion, how about you?
I'm aware of none, Your Honor.
Mr. Ringstrom, do you believe the court's in compliance with the court rules? Mr. Champion?
Agree with court has, Your Honor.
Court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements and both files. Therefore, in file 3425, she's found guilty of counts 1 through 6. Again, I think I said that earlier on the record on that set of probation violation allegations, and as to count 1 in file 3570. The enhancement will be dismissed at the time of sentencing. Ms. Raymond, sentencing will be done in about a month. You're going to have to complete a pre-sentence investigation report.
I'm the only one in my family with no criminal record, and all of my children are to the same person. Within a marriage. I was actually married when I had my kids. I know.
You're going to get a packet. You're going to complete that packet. You're going to turn it back into Ms. Odell. You're going to be subject to an interview. You have the right to have your attorney present. You'll also have to contact Mr. Champion will speak with you and go over that report. Once it's done, make sure that you go through it with a fine-tooth comb. Each side has the right to come back and request corrections or make objections to the contents of the report. The court hereby revokes any bond that might be outstanding, such as in the 2025 file, and remands to the custody of the Missaukee County Jail. Anything else, Mr. Ringstrom?
No, Your Honor.
And Mr. Champion?
No, Your Honor. Thank you.
Ms. Raymond, any questions about what we have done today?
No, Your Honor, thank you.
Thank you very much, ma'am. We are adjourned.
All right, here comes the dog. Here comes the dog case, which is confusing. Not that confusing, just, I don't know.
Let's start off with the case name. People of the State of Michigan versus Andrea Stewart, file 25-3576F8. Appearances, please.
Thank you very much, Your Honor. Robert, Assistant Prosecutor from Factual.
Okay.
Good afternoon, Your Honor. Lauren Kreinbrink appearing on behalf of Miss Andrea Stewart, who is present and seated to my left.
Thank you.
Stupid technology.
You may be seated. We're here today for the final pre-trial conference, but it looks like somebody told me that we're doing a plea. Mr. Ringstrom.
Yes, Your Honor. My understanding is that Ms. Stewart entered a guilty plea to a false pretenses, $0 to $200. People are doing the deal and they're requesting fines and costs under that. Also, we have no problem with something and sentencing at the court does not have a problem.
Is that just one count?
Just one count.
Of fault, did you say false pretenses or larceny?
False pretenses is $0 to $200.
All right.
And
is that a 1 year or is it a 90
it's an
day?
90-day, Your Honor. But then also both victims can have an impact statement if they want to.
All right, thank you. All right, Ms. Kreinbrink, is that right?
Yes, Your Honor.
Is that a correct and accurate statement of the pretrial agreement?
It is, Your Honor, and we would also have a signed advice of rights to provide to the court this morning or afternoon.
Yep, come on.
May I approach?
You may. All right, Ms. Stewart, have you heard what the attorneys have described to me as a resolution in this file today?
Yes, sir.
Is that how you wish to resolve the case? Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth? You may lower the hand. Make sure you speak up. You're soft-spoken. She needs to be able to hear you. All right, turning your attention back to October 9th of 2023. Were you on probation or parole at that time?
No, sir.
Were you on bond pending any felony charges at that time?
No, sir.
You are currently charged on a piece of paper called a felony information. It charges you with 2 counts of false pretenses where there was a value of $1,000 or more, but less than $20,000. False pretenses is a lot like a larceny charge, but it's where you got possession of something and you intended to defraud or cheat the other person or party. Each one of those is a felony punishable by up to 5 years and or up to $10,000 or 3 times the value of the money or property involved, whichever is greater. Each of those charges, however, will be dismissed if you enter a plea of guilty to, and the court accepts that guilty
It's not members only that I can see.
plea to, and added count 3. Added count 3 would be a very similar charge of false pretenses, but the amount would be anywhere from $0 to a maximum of $200 in value. Now that is a misdemeanor punishable by up to 93 days and $500 plus value of the property. But I'm also told that there's going to be restitution, which the victim or victims will request. Yes, sir.
That is correct, Your Honor, and that was part of the plea. I'm sorry.
I'm really
It's going to be $91 given to both victims, Raquel Park and then Rachel Park, $91 for each one.
How did it get up? I don't care. All right, so you're going to pay the restitution of $91 times 2. You understand?
Yes, sir.
All right. Is that how you wish to resolve it?
Yes, sir.
Please, I already did that. If you enter a plea of guilty, you're not going to have a trial of any kind. Does that make sense, Ms. Stewart?
Yes, sir.
I'm holding up a form that your attorney gave to me, and it says advice of rights, and it appears to have your signature. Is that your signature?
Yes, sir.
Did you read through these rights before signing?
Yes, sir.
Did you understand these rights?
Yes, sir.
And more importantly, do you understand that if you enter a plea of guilty and this court accepts that plea, you will be waiving those rights?
Yes, sir.
All right. Now, if I accept the plea, any appeal as to the conviction and sentence would be done by filing what's called an application for leave to appeal and not a claim to appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You'll also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me on the record. Have there been any other promises, threats, or inducements that I haven't heard about?
No, sir.
And are you entering the plea of your own free will?
Yes, sir.
Has anyone made any promises to you as to exactly what the sentence would be other than the guaranteed restitution that we already talked about?
No, sir.
No, and all that, you still wish to enter the plea of guilty as to added count 3.
Yes, sir.
As to added count 3, false pretenses up to a value of $200. How do you plead?
Guilty.
Before the court can accept that plea, I must have you tell me what it is that you did that makes you guilty of that offense. Turning your attention to October 9th of 2023 in Richland Township here in Missaukee County. What happened?
I sold a puppy to a young lady and then her mother got one and there was some back and forth about some vet work and things happened and
I gotta know more
she
than
was
that.
under the assumption that I lied about things and then there was a vet document that was created and sent to her.
All right. So you sold,
I was muted. Judge, it was crystal clear. You can just keep going.
sold 2 puppies, one to a mom, one to a daughter.
Correct.
And in doing so, they requested some kind of proof regarding vet bills, correct?
Right.
Thank you.
And you falsified some kind of document to demonstrate that there had been veterinary care.
Correct.
And how much did you sell the dog for?
I sold her for $1,000. I offered to take the dogs back and give her a full refund, but she didn't. She wanted to keep the dog in.
All right. But she wouldn't buy the dog unless you had given her the proof of the veterinary
No, she
care.
had already taken it and then called me
Okay.
and had a problem with the vet work. So I said, I can take the dog back to do all your money back. And she wanted to keep the dog plus, her money back. And then made some threats towards me and I clearly made bad decisions and
So, but your bad decision was to create the false vet bill document or record. Is that right?
yes, correct.
Okay. Where's the $91 come from?
Your Honor, the people believe, I'm not going to take away from the defendant, at the time of the sale, she had guaranteed that the dogs had shots. The dogs did not have shots at that time. at a later time. The $91 each is going for taking the dogs back to the vet to give them shots that were told that they had.
Okay,
So the dogs were worth at the time of the sale was $1,000 each, but the restitution being requested is only the idea of going back and having to give the dogs the shots that she had made statements of.
so when you sold the dogs, you told them they had the shots, which they did not have.
They did have the shots. We get the shots at Tractor Supply and give them to them ourselves.
So when
And
you
I
sold
told her
the,
that, and she said, well,
hold
the
on,
deposit is supposed to be for a vet visit.
hold on. When you sold the dog, did you say you received $1,000, correct?
Correct.
And did you lie to her about anything when you sold the dog to her?
Not at the time, no.
The lie came later.
Correct.
I don't understand that. I'll admit, I'm not very
so
bright, but
much. I appreciate it. Thank
So-
you.
Based off of the facts that she is saying right now, I believe that there is.
yeah, yeah. All right. Ms. Stewart, so far, at least what you're pleading to, or what you're telling me, isn't false pretenses. The false pretenses would be, I am selling you a dog that has had all of its shots. But I never gave one shot.
So, yeah, I understand. I guess the way I'm saying it isn't correct.
All right, well, let's
I
correct it.
did tell her that they would be seen by the vet and have their shots done at the vet, and they didn't
Venus,
get them at
thank
the vet.
you.
And so that is what was made
But
to,
they got the shots. But they still got the shots, right?
Your Honor, perhaps, and I'm not trying to.
Let's pick this up. We're at 10 after 12. All right, I don't understand what she did that's a crime. So she said they would get their shots from a vet. They got the shots. The person paid the money, got the dog, and got the dog with the shots. So she lied about them going to a vet, but they still got the shots. Don't understand.
Well, the way that she is putting it, yes, Your Honor, I could understand where the court would not understand. I believe that with what she is trying to say anyway, she had indicated that yes, they had the shots, that yes, she would be able to give them the veterinary proof that the shots were there. And then she did not give them the veterinary proof afterwards. She gave them a document that she.
So she falsified a document.
Yes, Your Honor.
The person paid $1,000 for a dog with shots. The person got a dog with shots. Are we serious? This is, oh my Lord. All right, well, and here's what we're going to do. I can't make a decision about what to do with the charges. That's not before me. I can, and am supposed to, and will, make a decision about the plea. The court cannot accept the plea.
Okay, so far so good. The victim is about to come up. Yep, the victim is coming up with a speech, guys. Just wait.
Because nothing she said meets the crime. And we are at 12:15, not 12:15. Therefore, the court will continue the case set on the trial docket. If the parties are able to reach some kind of resolution and want to enter it on the record by the end of next Friday, they can do so. By the way, if the evidence, and I don't know, I only know what I've heard today.
Your Honor,
Yeah,
I don't mean to interrupt,
that's
but
okay.
could I,
That's okay.
with my client, could I attempt to question her to establish a factual basis? I think she just has some confusion as to what the court is looking for.
Okay, we'll go for it.
All right, thank you, Your Honor. So Ms. Stewart, on or about October 9th of 2023, were you selling dogs in Richland Township of Missaukee County?
yes.
Okay. And did you sell a dog to a Rachel Park?
Yes,
Did you sell a dog to a Raquel Park?
yes.
Okay. And as part of that transaction, the sale of the dogs,
I don't think it's neglect. I don't think it's that point. The dog did get the shots. The dog is healthy. And no one hurt the dog. The dog's not hurt. Well, shots hurt. So the vet hurt the dog. Well, not the vet, the tractor supply person.
did you provide veterinary documentation to both of the parks indicating that the dogs were in good health?
Yes,
Okay. Did you in fact take the dogs to a vet for shots and for inspection to ensure they were in a good health, or did you do that by another means?
I gave them the shots from Tractor Supply.
Okay, so the dogs did not receive the shots from the vet, correct? But during the sale of the dogs to facilitate the transaction, did you provide documentation to the parks indicating the dogs had been to the vet and had been taken care of by the vet?
Before they took the dogs from me?
Or during the sale, during the transaction?
From the time when they took the dogs from you. When they took the dog, that's what I need to know.
When?
Like at the time of them taking the dogs and me taking the money, did I give them something?
Yeah, so did they take the dog? Did you give them the paperwork and they took the dogs? Is that what happened?
They took the dog. I took the cash, and later on is when the image of the document was sent to them.
But when did they ask for that?
Kathy's having
The day
issues
that they picked the
again.
dogs up from me. And I said I forgot it at home and that I would send it on later.
So how much later after they took the dogs did you provide the paperwork?
I'd say it was the same day.
It was the
Um,
same.
The next day that it was sent through a message.
Okay.
Your Honor, I do believe there's enough based off of that, based off of her saying that at the assertion of the time of the sale of the dog, she said she would supply that paperwork that she did not have at that point in time. I will just
At the time they left the dogs, at the time they left with the dogs, had you promised them that you would get them paperwork that you knew did not exist?
Yes.
Okay. Court finds the defendant's pleas were freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record satisfies the elements of the offense. Therefore, the defendant is found guilty of added count 3. Counts 1 and 2 are hereby dismissed. Can we proceed to sentencing?
We could, Your Honor.
Go ahead. Make it.
People would be okay with finding the costs, however, we do have victim impact statements.
All right, go ahead. Bring them on forward. Anything else to add?
A letter from Rachel Park, and then we have Raquel Park who is present.
All right, Ms. Park.
Here we go. Here we go, guys.
Ma'am, you are
Get your
Ms.
tissues.
Raquel Park, R-A-C-H-E.
It's R-A-Q.
Oh,
Yeah.
okay. I'm sorry, I was just.
That's okay.
All right, go, I think, just spell it again for me. Yeah.
Okay, yeah. I'm
It's
sorry,
really
Your
for
Honor.
her. It's for
Rachel
her.
Raquel gets it screwed up.
Yeah.
All right, my name is Raquel Park. I'm here today to speak on behalf of myself as a victim of a puppy scam that has caused financial and emotional distress. On September 29th of 2023, encountered the defendant who was advertising a puppy for sale on the website. The defendant stated the puppy would come with official legitimate puppy records that included information on the puppy's breed, vaccination, health history, and other details to make the sale seem credible. I relied on these records, trusting the puppy was in good health and the transaction was legitimate. However, after making the payment and receiving the puppy, she stated she got the paperwork and would get to me immediately. I had to keep persisting, and she stated that I didn't need to provide the records to my vet for proper care. When I did my research on my own and consulted the veterinarian, I discovered the puppy's records were false and she had forged veterinarian's signature. The spectrum of the scam has been devastating. The money I lost and had saved to make the puppy was healthy should never happened. I then had to make my own appointment right away to make sure the puppy was healthy. This also doesn't include the expenses of work costs, travel to pursue the scam. That it's not only affected by my employer, but my employees I have to cover for me for court. The defendant's actions have shaken my trust in others, and now I find myself second guessing decisions I make, especially when it comes to online purchases or interactions with strangers. I have become more cautious, paranoid, even feel a sense of vulnerability that I never experienced before. I feel I was taken advantage of, not only financially, but emotionally, as the excitement and anticipation I had for this puppy turned into feelings of shame, anger, and disappointment. Andrea Stewart's husband called me vulgar names and threatened me just because I asked for what I paid for the health of the puppy. Andrea Stewart works at a bank. I feel the bank should be notified of her accident, as she's not a trustworthy person that scams people and sees people for money. I know there are other victims out there that just did not report what she did, but I'm here today to hopefully stop the scam from happening to somebody else. Her family also was involved with this scam, so shame on her family for keeping the scams going. Your Honor, I understand no amount of money or words can undo the damage that has been done. However, I ask the court to recognize the importance of the crime committed by the defendant. Defendant didn't just take my money, she exploited my trust in providing falsified puppy records, leaving me devastated. I hope that by holding the defendant accountable with the maximum sentence, others will be deterred from committing similar crimes and the victims can find some semblance of justice. Thank you for your time.
Thank you, Ms. Park. Defense, anything to say?
Just, Your Honor, that we would ask the court respectfully to follow the agreement as we think it's fair and reasonable. My client also has no objection to paying requested restitution in this case.
All right, thank you. Ms. Stewart, anything you wish to say?
No, sir.
All right. Ms. Park, we let you in on a little not so secret fact about the law. Even though you might look at this and say the maximum punishment is up to 93 days. I want to say yours, but our legislature said in 2020, even though it's up to 93 days, you can't give 93 days. That's it. I'm actually not even supposed to be able to give her probation. Why? Because I'd have to find reasonable grounds. Does she have any priors?
She does not, Your Honor.
Bingo. So the maximum.
She'll do it again.
I know. Trust me.
Why we brought it.
Trust me. I understand why you brought it. I just want you to know that the maximum time is actually 0, despite what the law looks like it says. So the court does not place the defendant on any probation. I have to follow the law. The court does assess fines and costs. $50 state minimum fee, $75 crime victims' right fund fee, $100 court
My cats
cost.
do not love me.
There is no attorney fee since counsel is hired, correct, ma'am?
Correct.
So the maximum that I can give her is $500 in fines, which I do assess $500 in fines. So in effect, that is the maximum punishment the court can allow. And I order the $291 restitution fees. All right. Thank you. Anything else, Mr. Ringstrom?
No, Your Honor, thank you.
Counsel, any clients?
Nothing further, Your Honor.
All right, thank you. I apologize. I know I got the name wrong. Thank you. We're adjourned. All right, we are next taking up the case of people of the state.
That poor lady. We should start a GoFundMe for her to help her out. I don't know. She seems very shooken about the shots not coming from a vet. No, my cats do not love me. They love when I feed them. They will pretend to love me when they're hungry. When they are not hungry, they don't even pretend. They just walk away. I wonder what the name of that GoFundMe should be called. Stop Devastation. Stop Devastation. Oh, I got a hole. Okay. Yes, it is, Linus. It's very professional. Hi, Belle. Okay. Now, I guess I think I want to feel bad for this guy, but I don't. But there's one part that I love when his wife needs glasses. Wait till you see.
You need to unmute yourself, please. Click on that microphone. And what docket is Ms. Huff on? Bless you. I see. I see that. Thank you. Thank you very much. All right, Mr. Ramirez, if you can hear me, can you raise your hand if you can hear me? Thank you. All right, what you need to do is you need to take yourself off mute. At the bottom of your screen, you'll see a little icon or diagram of a microphone. And you need to click on that. Click on that, and then
Rip the glasses off of him.
you will have sound. There you go.
They're
Thank you very
married,
much.
you can tell.
There you go. Oh, here. All right. Mr. Ramirez. All right. We are appearing by Zoom. We are appearing virtually for to make access for the parties convenient and efficient.
That is one good point about marriage. She just needed glasses. He was right beside her, so now she she has glasses. It reminded me of the Fates.
I am finding that there is good cause to appear by Zoom. You've indicated by your hand that you can hear and see myself and the attorneys. Is that right?
Yes.
All right. Thank you. Please call the case.
Anthony Ramirez, 24CR95514 on pre-trial, as well as to address what I call 4 guard violations, alcohol monitoring violations.
Thank you. All right. And I am looking at the violation report that was filed on March 12, 2025 from Sentinel EHM non-compliance notice, and it reads on March 7, 2025, the above named defendant, referring to the defendant who is present on Zoom, failed to take 5 consecutive bar tests.
And that would be, is that number 5, EHM non-compliance number 5? I don't think I have a March date.
I believe that. Yes.
Okay. I have through 4, Your Honor, so now it sounds like there's 5.
All right.
So at this point, so the city's request is to.
Okay, let me, I haven't heard from defense yet, their introduction, and then I'll hear from the city's recommendation.
Yes, Your Honor. Nick Delay, Department of Assigned Counsel, representing Mr. Anthony Ramirez, on behalf of his attorney of record, Ms. Nicole Bonfin, who,
It's one of those devices you have to blow in. So he has a device at home that he randomly has to blow in when it goes off to make sure that he's not drinking. And he's not been blowing into it. And a few times when he did, he blew with some alcohol. Not over the legal limit to drive or anything, but he had alcohol.
Mr. Ramirez is appearing on Zoom for this meeting. Ms. Bachman is logging into Zoom now as part of this. At this point in time, I have notes for the pretrial here.
Oh,
but,
are you on mute? So you can be heard.
yeah.
Sorry. Yes.
Boy,
Okay.
Zoom
And
is
who
hard.
is logging in right now?
His attorney of record, Ms. Nicole Bachman.
All right.
He doesn't share. She just grabs it. Whatever she wants.
Could I get a breakout room with Mr. Ramirez, please?
Yes.
How is he going to get into a breakout room?
Ms. Backman, we can't see you. Your camera's off.
Now, you don't get to see when they come out of the breakout room because every time I tried to record that part, this video froze on their site. So I kept rewinding, I kept fast forwarding, I kept trying to get it, but I couldn't record it. I could watch it, but every time I pressed record, it wasn't working. So we get out of the breakout room, and him and his wife are trying to unmute it. And his wife says, it's already unmuted, by the way, so we know what his wife says. His wife says, oh, there's a button that says leave. Maybe that's the one we should hit. His lawyer, a lady, you'll see her soon. She's very pretty. Speaks up and says, no, you're fine. Just be very quiet. And because the lawyer spoke when she wasn't supposed to, the judge comes back on and says, well, everybody please stop talking and mute yourself. Get a boyfriend
All
like
right.
that one.
Is there another case that we can take?
Yeah.
Mr. Ramirez, you're going to get an invitation to a breakout room, and you're going to need to click on that to go into the breakout room with Ms. Backman, who's already in the breakout room. Do you see that?
No, I'm not too computer savvy.
That's okay. We're going to lead you through that. It should appear on your screen as an invitation to a breakout room.
There.
Bye, Tanya.
Did something appear on your screen?
So I'm supposed to push join?
Yes. Click on join. All right. I'm going to
This courtroom is crazy. Zoom is so hard for people. I'm not showing you Cassandra's case because she just walks around the whole time. You know, it's so annoying. This is it. I thought I didn't get it. I thought I missed it. Oh, yeah, I got it. I thought I cut this out.
all right. Are we ready to proceed on Mr. Ramirez? Ms. Backman, are Are you with us?
Yes, I'm here.
Great. And I will get to the right docket.
235, if you remember.
Thank you. Please.
Now, I want to feel bad for him because, I mean, look at him. He's having issues just operating
Right, please
Zoom. So I
call
want to
him.
feel bad for him, but I
Anthony
don't.
Ramirez, 24CR95514, on for pretrial as well as to address the BART violations that were noted at the prior hearing. I believe those were just violations 1 through 4. I will also note at that hearing, the defendant was referred to hook up to Scram and presumably discontinue with BART. I don't believe that there's been a Scram hookup, so I'm not sure why that has failed to happen. But the city would like to heard on conditions of Michelle Wilson.
Thank you. Yes, Ms. Backman, please go ahead.
Thank you, Nicole Backman, Department of the Sign Council, on behalf of Mr. Ramirez. So I haven't had a chance to briefly look over those violations. They're all from March 7th of this year with a successful completion of BART on the 8th. In speaking with Mr. Ramirez, he's not sure what exactly he was doing on the 7th, but it's not an allegation that there was any alcohol or any tampering, just that he did not take the BART test. So my understanding with BART is that it goes off and then you have to blow into it. At the last court hearing, Ms. Doyle is right. Mr. Ramirez was referred to Scram because he was having this issue where he wasn't always noticing when the BART would go off, and then he had some violations at the last court date. So that's why we had moved him over to Scram. I talked to Mr. Ramirez some more about that. He did not realize that he had to go down to the courthouse. He does not have a car, so he has to walk down to the courthouse, which is a pretty long ways for him. So I've explained to him that that's what he's going to need to do to get hooked up with the Scram monitoring. I believe he understands that, and he understands what he's going to have to do moving forward with Scram. BART is just not a good fit for him, and I do believe that he understands now what he's going to have to do.
Thank you, Ms. Backman, and I want to make sure that we have a complete record that is clear. So the violations that you are referring to are the violation, a non-compliance notice number 5, and that was from March, and that was March 12, 2025, and that was for, I believe it was 5 missed tests, not 1, 5 on one day. And then I believe that there was also on February 12, 2025, I think you referred to that. That was for non-compliance notice number 4. And on February 10, 2025, there was a non-compliance notice number 3. And on February 10, 2025, there was a non-compliance notice number 2. And on February 7, 2025, there was non-compliance notice number 1. Did you have anything to add about those?
Nothing to add, Your Honor, except for Mr. Ramirez. I do not think that he understands how to use BART. I think that there are some potential competency concerns that I have with Mr. Ramirez. So just so the court has a full understanding of what's happening, Mr. Ramirez is not intentionally blowing off this device. I truly believe that he does not understand, and that what would be best is that I'm able to continue to talk to him about his options to gauge if there are going to be any 1077s that are filed, and get him enrolled with a more foolproof system, which is just on his ankle that he does not have to be responsive to on a daily basis because it's not working.
His wife will grab it off anytime she needs it, though.
I'll hear from the city.
Thank you, Your Honor. So I'm looking at, non-compliance notice number 3. That's for February 8th through February 10th, where there were 11 missed tests.
Oh,
What's concerning, however, is that at the very end of the first paragraph of the comment section indicates the alcohol readings of the failed BART test was 0.062. Your Honor, Mr. Ramirez has 5 priors, one of which is a successful deferred prosecution that was dismissed. However, the deferred prosecution requires an individual to admit that they are an alcoholic, have a problem with alcohol, and should not be consumed. So he has already done that. He was given this opportunity, and actually, $50,000 bail was initially imposed. He did bail out. In order to scram, for whatever reason, that did not happen. He said hooked up on BART, and he's not been successful with BART. Keeps missing. I mean, we're looking at 8 missed, 11 missed, 6 missed, and then we have a positive for alcohol. This is incredibly concerning. City has extreme safety concerns here. He is drinking. And so I think it's appropriate at this time to increase bail. I'm asking for a $30,000 bail. And if you could post that amount, I would ask for him to not be released without taking up on scram first.
Ms. Backman?
I did have some additional information about the violations in February. During that time, Mr. Ramirez was picked up and he was arrested, but ultimately NCF'd. So that was why he was away from the BART device and not able to do it at that time. So that does explain some of his failures to complete the tests from back in February. But as the city has stated, clearly this is not a successful situation for him. I do just want to reiterate that there are some competency concerns with Mr. Ramirez. I do not believe that he is willfully not taking these tests. I think that it's just a complicated thing for him to remember to do. And I don't believe that sending him to jail is going to be appropriate. He does not have a vehicle, so he is not driving. There's no way that he can possibly harm other people in that way at this point due to his lack of a vehicle. So I would ask that we consider maintaining the PR and he be given the opportunity to put on a scram bracelet as soon as possible on Monday.
It's not a PR release on $50,000 bail. I guess I'm trying to clarify, is defense filing the 1077?
I do not want to at this point, but it is a borderline consideration that I have. I would appreciate some more time to be able to talk to him and to be able to speak with him in person too.
All right. Thank you. I think the bail was previously Ms. Doyle, Ms. Backman, 15,000. And the city is now asking for 30.
Yes.
All right. I agree with both attorneys that this is not working, but first I'm going to ask Mr. Ramirez to please take yourself off mute and state your full name for the record. Okay, Mr. Ramirez, yeah, there you go. Okay, Mr. Ramirez, can you please state your full name for the record?
Anthony Allen Ramirez.
And Mr. Ramirez, I want to confirm your address on East E Street in Tacoma.
Yeah, that's 4640 East E Street.
Sorry,
Thank you
I forgot
very
about
much.
that.
All right, today we are here for a pre-trial hearing for the charge of driving under the influence, and that had a date of violation of December 13, 2024. because of conditions of release involving electric home monitoring, there have been 5 non-compliance notices indicating both failing to take the test when required and also indicating a presence of alcohol on compliance notice number 3.
It was hair dye.
As I said before you introduced yourself, Mr. Ramirez, it is clear that this is not working for you. And it is not working for the city as well. And there are safety concerns, not only because of the notice of non-compliance, which there are 5 of them. Not only because, just a minute, please. Not only because of the presence of alcohol in the 3rd non-compliance notice, but because of your history, and I'm looking at that right now, for driving under the influence, which indicates a significant and ongoing problem. Now, the SCRAM, an alcohol monitoring device, was authorized, but did not happen. So at this point in in your proceedings, I find that there is good cause to accept the city's recommendations of $30,000 in bail and for you not to be released until you have that SCRAM device put on. So I want to make this reasonable in terms of when you can report to the jail. So can you report to the jail on Monday?
Exactly.
Can it be in the middle of the week?
Any objections to Tuesday?
I didn't hear the response.
Mr. Ramirez asked if it could be in the middle of the week. So I said, are there any objections to reporting on Tuesday?
Yes, Your Honor, if this was happening in person, I'd be asking for remand. So I think Monday is already putting public at risk, quite frankly.
All right. Based on the objection from the city, I'm going to make the order will reflect that you need to appear at the jail on Monday by 5 p.m.
Is that for me?
That's for you. All right, and I'm going to go over conditions of your release. I'll do that right now.
Well, I got Monday at what time?
By 5 p.m. So you have the whole day on Monday, and you have to get yourself to the jail Monday by 5 p.m. And the conditions of your release include maintaining law-abiding behavior with no similar incidents, keep in contact with your attorney, keep your mailing address updated with the court and your email address. Do not drive a motor vehicle without a valid license and insurance. I know that there was a declaration of non-driving filed, I believe. Here, also, no consumption of alcohol, no consumption of marijuana, no mood-altering substances or marijuana use unless prescribed, no refusal of a breath or blood test, and to comply with all SCRAM conditions. And you have to enroll by the close of business. Thank you. By the close of business on Monday, March 17th. I will tell you, and I've just been handed a note, I want to make sure that you report when the jail is open. So for Pierce County Jail, which would be more convenient to you perhaps, the hours are 9 until 1 p.m. or after 4 p.m. All right.
9 until 1?
9 until 1, 9 a.m. until 1 p.m. or after 4 p.m. That will appear on your order. And the next pretrial conference will be when?
I would actually say.
Ms. Backman, that works for you, no more than 2 weeks?
No, I did not hear the date.
We didn't have a date yet.
Oh, okay. Well, I intended to file a speedy trial waiver. I guess I don't intend to do that anymore. I would just ask for the soonest date possible.
All right.
And then
Just don't put them in your ears because it says so right on the package.
don't even know the time to make it.
All right. So,
That's fine.
okay, did you hear that, Ms. Backman? And
No, I did not hear anything.
Okay, so we can have a court date for March 18, which is the Tuesday. And what time would that be?
3 p.m. 2:35.
3 p.m. and 2:35. And is that virtual or in person? In person. So that's in person, 2:35, 3 p.m., March 18, which is Tuesday. All right. Ms. Backman, does that work for you?
Yes, that works. Thank you.
Mr. Ramirez, we have a very quick court date for you because of the conditions of your release and the bail. So that's March 18, which is next Tuesday at 3 p.m. in courtroom 235, and that's in person.
Okay. At 1 o'clock?
No, that's at 3 p.m.
Oh, 3 p.m. I'm sorry.
That's okay.
Oh,
So
now
it's
it makes
March
sense.
18th at 3 p.m. in person.
Courtroom 235.
Okay. What was the violations for this? I've blown in this forever and it's never been, I haven't had a violation.
Yes, just a minute, please. Thank you. All right, and I do want to state, and this will also appear on the court order, that if you do not appear, if you do not go to the jail on Monday, and I've given you those 2 times for Pierce County Jail, and if you choose to go to Nisqually,
That 5 violations was just 5 violations on that one day. He's had way more than 5 violations.
the The Nisqually jail, that's open from 8 till 5. But if you do not go, a bench warrant will be issued.
And that's Monday I come in?
Monday, you report to the jail.
All right.
Tuesday is your court date.
All right. So I'll be in custody for the court.
You will be in custody unless you post bail, and that's unless you post bail.
Oh, okay.
And that's cash or bond. And then your court date will be on Tuesday, March 18 at 3 p.m. in person. You're going to get a court order and it'll have all of those dates. And if you have any questions, you can ask now, or you can call Ms. Backman, your attorney.
Okay. What's March 18th on Tuesday?
March 18th at 3 p.m. in courtroom 235.
Oh, okay.
Is your court date. And it's very quick because your attorney requested a very short time because you might be in custody.
He will.
Right.
Definitely.
Do you want to go over
custody.
those dates again?
Well, it's March 18th at 3 p.m. room 235.
Right. But on Monday, you need to report to the jail. And the Pierce County Jail hours are 9 to 1 p.m. or after 4 p.m.
All right.
If you do not report to jail, then a bench warrant will be issued.
And that's Monday, right?
That's Monday, March
Okay.
17th.
I guess I'll be there at 5.
Be there after 4 p.m.
You couldn't
Oh,
just give him that one.
Okay.
You could. He said he'll be there at 5. That's fine. You had to confuse him more. Now you're gonna confuse him even more. Okay, go ahead.
Monday after 4, right?
You can also go in the morning from 9 until 1.
Okay. And that just goes to the courthouse, right?
No, that's you report to the jail.
Oh,
Thank you very much. You're going to
that's
see
Monday?
you're going to see the address for the jail on your court order. Thank you for including that.
all right. And how long is that going to be for?
Mr. Ramirez, well, you're going to have your court date the next day. So I can't answer that for you. It depends on if you make bail and the next court hearing, which will be on March 18th. All right. So the date to remember above all is Monday. Monday, March 17, when you report to jail, Pierce County Jail, the address will be on your court order. And I know you're writing this down, from either 9 to 1 or after 4 p.m.
That's when I report to jail?
That's when you report to jail.
All right. I guess that's all I need to know, huh?
Yes, that's very important information for you to know, and and for you to appear at the jail on Monday, the 17th. All right. Ms. Backman, is there anything else on this case?
Nothing further. Thank you.
All right, thank you. And for the city, Ms. Doyle, anything else on this case? All right. Good luck to you, Mr. Ramirez. You'll get that court order. Do we have an email address? Okay, you'll get that by email, that court order, and it has the information regarding the jail and the address for the jail. Okay?
Yeah. But it doesn't say how long I got to be there, huh?
No, it does not.
All right.
All right. Thank you very much, and you can exit from the Zoom hearing.
Mish, thank you. Yeah, everybody's going through it right now, Mish, everybody. But hopefully these videos, you could just remove yourself. This is what you do instead of the cocaine and the heroin and the meth that we were talking about earlier. You watch videos. Yep. And then you see other people who have it a little bit worse, and then you feel better. And you feel better. At least I'm not reporting to jail today. I don't think. So far, I'm not reporting to jail today. Crystal, good question. So I start my new schedule right away. So yeah, there will not be a stream tomorrow, and there will not be a stream Saturday morning, because I picked up 2 new shifts at work, and there's just not enough time in the day when I only get 12 hours off in between work, and it takes me that long just to find 2 hours of content. So yeah, I won't be streaming tomorrow. I won't be streaming Saturday. I had something else I wanted to tell you, and I can't remember now. I got knocked off my game because my camera's not working. Yeah, so oh yeah, thank you. Donald reminded me. Donald reminded me what I wanted to say. So the way the restaurant industry works, it's a little crazy, okay? So I'm working Saturday night, and I say to my boss, what time do I get off tomorrow? What time do we close? So Sunday, no one really knows what time the restaurant is open on Sunday. We have no idea. So I'm like, okay, say what time do I work till tomorrow? What time are we closing? He says, kitchen's gonna close at 5 and we close at 6. All right, bet I can make it to Bill's stream. No problem. I get to go home. So I get to work on Sunday. And I'm working and I'm working and I'm working. And then the other boss comes up to me and he says, oh, by the way, I don't think I'm closing at 6 tonight. I'm going to keep it open. He didn't ask me. He didn't say, hey, do you mind if we, stay open a little late today or whatever? He just said, yeah, no, I'm just going to keep it open until, and he didn't even tell me what time he was going to keep it open till. He says, we're just going to keep the doors open today until it slows down and there's no one left. And I'm working like, what? What do you mean? What do you mean you're just going to keep the doors open? If you could just give me a rough estimate on what time I might be home. Now, I don't have any small children anymore, so it doesn't matter. It's fine. And I'm very, very glad that he made that decision too, because a whole bunch of people came in after 5 o'clock, and I was very happy because I was all alone. It was just me and the boss and the cook in the back. And the people who came in, they were like, oh my gosh, are you all alone? Yeah, when I hear those words come out of someone's mouth, normally they give me an acceptable tip. Don't worry, guys. Bill's going to stream tomorrow. Bill's going to stream tomorrow with Judge Fleischer's docket. So just go there. Speaking of Judge Fleischer's docket, I started with him not even there. Ramona, was that Ramona?
So we'd be like, how are you this
Ramona, hi Ramona.
Okay. How are you, sir?
Hi, Russell. How are you,
I
man?
have Omar Syed.
Hey, fix your collar.
Jacket or?
Sure.
No, I just don't have shirt stays in there today. Can I approach?
I'm live streaming, so I don't know if there's something you want to say.
Kelly, I saw that video before. Not Kelly sent me an accent video. And Kelly, I've seen the original video before, not the video of the Irish guy telling me what he thinks about the video. I've seen the original video before, and it, like, they picked some good ones, but they could have picked some really, really good ones, and they didn't. So that one kind of hurt my heart a little bit. I think we can do better. I think we can find a better string of Southern accents, and I think we could test people here and see if they can get it. I think that's what we should do. We should do something like that video, only better. Hi, Terry. I think that would be a great members only. No, I don't think we should do something that someone else already did. I think we should find our own, like find our own little TikTok of Cajun, and a TikTok of Tennessee, and a TikTok of Louisiana, and see if anybody can guess where they're coming from. It would be great if everybody from Texas messes up the people we get from Texas. We could just get Carl on here for Texas.
Well,
Hello. Yeah.
do you know what your lawyer had worked out for you to do, sir?
Today?
No. What you were supposed to do between the last setting and today. What were you supposed to do?
They told me I needed to go to a mental health evaluation or something like that.
All you had to do was walk in, tell them that you're there to do it, and then they would have done the assessment.
Okay.
I don't understand why it never got done.
I would suggest not a reason because he's going to give you a week. That's my suggestion.
Yeah, that's all I need. Okay, so.
Your case is 250 days old.
Yes, sir.
Unacceptable that it's gotten this old.
I know, sir.
I will give you a week. If you don't have it done in a week, I'm going to set your case for trial, and I'm not giving you any more resets.
Okay.
To trial.
That's good enough, sir.
1 week.
Yes, sir.
If you
Yes,
don't
sir.
understand what to do, Mr. Newman can help you out.
That's why I
Just no more excuses.
Okay, yes, sir.
Thank you, sir.
Thank you so much.
I'll get you. Sir.
Another Smith, thank you so much. Thank you.
Yes, ma'am.
I'm here today on Carl Lee Powell. He's in custody.
Yay,
It's a
Terry,
bail review
7
setting.
months.
He has a felony attached, and I spoke to DVD about
No, that's
the
just South
situation.
Georgia.
And it is a little confusing because it appears when he was in felony court, the residence that he's supposed to stay away from is actually his mother's residence where he lives. The complaining witness is a roommate that he let a gentleman and this gentleman's girlfriend move in with him. And so
In her house.
in her house with the mom.
Right.
With the mom. And then the allegation is that the complaining witness stated that he, assaulted her on a different occasion. And then that's when the charges were filed. So,
Complaining stated that Mr. Powell.
yes,
Okay.
assaulted her.
Okay.
And then charges were filed and he was given bond conditions. And at that time, like January 31st, a MOET was signed. Okay. And he had an ankle monitor. But the complaining witness then went to a rehab facility for crack addiction, I believe. And so when she was out of the house, he goes back to felony court I mean, he goes back home, he goes back to felony court. The judge allowed him to amend the bond conditions so he can go back to that residence.
Sure.
Yeah, that's when I spoke to DVD, but the problem was the MOAP was still in place when he went back to the house. So I think it's a violate bond condition and a MOAP, but since that time, I guess, when he spoke to, Judge Peebles, that he amended the bond conditions, removed the ankle monitor, and allowed him to go back home. In this court today, the violate the protective order is alleged to have occurred that the complaining witness went to the house where his mom lives to get her stuff because she was told she had to move out because her boyfriend now is in custody for a different offense. So she was asked to leave the residence. The mom didn't want.
Since the judge shaved his beard, should I shave the beard I'm trying to grow?
Her there. So she goes back to get her belongings. And that's when she encounters Mr. Powell's in the house because he's been living there with his mom. And so she does state, I think, in her, in the probable cause that he did not threaten her or he did not assault her, but here we are. I mean, it's a black letter law, right?
Yeah.
So obviously, I think everything's going to hinge on the felony case.
Yes, Judge, and we have notes as well saying that the felony court did remove that condition. It's just uncertain why they didn't amend it in the MOAP as well, but the bond condition was removed after it was found the complainant no longer resided at the.
Oh, holding him at no bond too.
Right, so.
I don't understand how.
And then that's what I'm saying. And he does go back to court on the 19th.
No?
For
I
the
mean,
felony.
with our case, the problem is that he's still in communication with her, which is still a violation,
That's
right?
what I call
You
you.
can go back to the house. You just can't, I mean, and I'm assuming the only reason he could go back to the house is because she's in rehab and she's gone, right? But for her being in rehab, he still wouldn't be able to go there because I think the idea is that they don't have communication together.
And I think the
Problem
date
is-
was the February.
And
Yeah.
what I don't, the problem upstairs is they didn't try to anticipate if and when she would leave rehab to go back home, because if he's there, which he probably has nowhere else to go.
Right. According to our case, she was there to get her belongings and that's whenever they came into contact with one another.
So ours is a good case then.
Yes, technically because it's based on the MOAP that wasn't amended, so.
No,
Because that's the.
no, but they still are having contact.
Yes,
That's the problem.
Just as,
Not the fact that he's
just
over.
as pled.
Well, he lives there. She came over to get her clothes because she was kicked out. It's his mom's house of 40 years.
Right.
Yeah.
Right.
And then she came.
And his mom is a complaining witness.
No,
Who's a complaining witness?
Complaining witness.
he moved
a
in
roommate.
basically to crackheads to the house. And it's a guy and the girlfriend. And then the girlfriend had to leave. And then the boyfriend of that girlfriend, it's not him. So basically he moves in two buddies, two friends.
Right. I get that. So it says here,
And the woman is the girlfriend of the
one guy.
Yeah, one
So
guy.
that's Miss Scott.
Yes, yes.
Yes,
So that's Miss Scott's not.
not his
not-
mom.
not his
It's
mom.
not his mom.
Good.
So Miss Scott, those are the her clothes.
Either, I don't know, I can't tell from the pleadings and what I've read, if it was before she was in rehab, after she was in rehab, or during rehab, when she goes back over there to get her stuff, because somebody, it indicates that someone told her she could no longer live there.
So it says here, did violate said order by intentionally and knowingly going to or near a place specifically described in the order to a residence of a protected individual, namely this address, right? I mean, if you're telling me that it was amended to where he could go there, I'm going to find no probable cause.
So we understand because the bond conditions were
Right.
amended in the felony.
You want to take a look just to make sure? Because it will affect an upstairs case. Howell.
And Judge, what we have, and just to be clear, the bond conditions were amended.
Yeah.
The MOAP was not amended, and that's what this PPO is based on. Just to make sure that the facts are.
And then according.
There's two.
Was that an oversight on their part upstairs?
It appears
We
so.
don't know.
It may That probably was.
There's no note anyway.
But the bond conditions were amended for him to be able to go back to this.
To that same residence, Your Honor, yes.
And they removed his ankle monitor as well, so there was no exclusionary zone anymore.
And here's the rub, though. They're holding him at no bond upstairs, and then now for another 2 more days.
But the bond is removed.
I'm gonna find no PC. I mean, I can't.
This might be one I need to kind of go talk upstairs about.
You want to email them real quick and see?
So
I mean, we have it.
the DVD prosecutor did come down, and basically he was saying, obviously it all depends on the felony, but he also indicated that the MOF was still in place when the alleged.
Every right to be there because they amended the condition for him to be able to go back.
But I think they're saying the offense occurred before the amendment was made.
That's a different story then.
Yes, Your Honor. And so
Say that they amended the condition.
sorry, Your Honor, the other thing is this is a,
February 14th, and this office date
Oh.
is.
So what happened is when he went to the location, he got a bond violation. And so he appeared in felony court after that, and they amended it.
But he's still nevertheless.
Right.
Your Honor, before, I just asked for before
I'm not going to.
decision.
Because this is the date, but it's the date before the conditions were modified. He still is going there when he's not supposed to be there. Right, okay.
But I was asked if he would reduce his bond.
It's at $500.
I know, can you reduce it to 100?
Let's do this. I don't know yet, because obviously
Sorry,
he's
Miko,
still
that was
doing
an
whatever he
accident.
wants to do. And I have concerns, Why don't we set this for the 20th, which is the day after felony court? Let's see what happens over there. And if they give him a PR bond and if they're okay with releasing him, then.
Your Honor, this is a DVD case as well, and so I'll have the DVD prosecutor.
Okay. Yes.
Okay.
So
So we're gonna roll it to the 20th.
I would say, yeah, Thursday's the 20th so that we can,
Sounds good. All right, thank you.
I mean, if it was after, I'd find no problem because all day. No.
All right, thank you.
Yeah. Ready? Hi, Mr. D.
Thank you, Judge.
Thank you.
Your Honor, I am here on Miss Jessica Sanford. It looks like Miss Sanford picked up a felony offense while on bond for your case in your court.
Okay, I'm gonna have, let me talk to them first because I need more time with you.
Yes, sir.
If you don't mind. All right. You ready? Are you ready? That's okay.
Mr. Matthew. Shh. It's a bond violation.
What's the last name? I don't know yet because.
Within the yard.
They're both on page 6.
Okay.
Mr. Mayor, he's been approved for the DWI PTI program. Your Honor, the only thing that's outstanding is the TRAS. We need to get scheduled for that.
Great. We'll do that. We'll send him for a walkthrough now. If he's here.
Yes, sir. He's in the back.
Figueroa.
And Mr. Figueroa, but Mike texted me that he's been denied. So Mike wanted me to reset it to give him some time to figure out. And it's my understanding the state has made a time serve offer, but on that,
It's 190 days old.
Yes. Okay, Your Honor.
And let Josh know he's got to be here in a week to decide what they want to do.
We set for a week on? Okay, all right. Thank you. May I be excused, Your Honor? Yes, sir. Thank you.
So, and then on Emmanuel, we'll set it for like 2.5 weeks.
Okay, Your Honor. Okay.
To get the interlock, the results of the TRAS and all that stuff.
Okay, Your Honor.
On 1 week on Figueroa.
Clear trial. Okay, hey, you ready? Okay, I'm gonna skip you then, and then we'll, come on, you ready? Hi, good morning. Sure, I guess so. It's on Dean. Thanks. While we're waiting, anything else? Okay, let me talk to them real quick. You ready? Come on.
Melissa Wilson.
Okay. Okay. Marissa Wilson, come up.
Follow is during the
And then.
I'll sign and trust
Ms. Wilson, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated for 18 months. As part of this agreement, you will do a DWI education class. Is it a true first state? You will do
It's
a,
true first.
you will do a DWI education class. You will do, I guess there's no victim impact panel. You will do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them. Random urinalysis, no drugs, no alcohol, guardian interlock, 20 hours of community service, and a $100 one-time donation to the Houston Food Bank. Is this how you understand this plea bargain agreement? You need to understand that you're here on a bond violation today because you failed to appear for a drug test. If you do the same thing while you're on probation, I will issue a warrant for your arrest. And we're going to have a hearing as to whether you're going to be doing 180 days in jail. You have to do stuff on time and you can't skip. I don't care what's going on in your life. If there's a choice between probation and something else, what is the choice that you have to make? Right. Because if you don't, you could be facing a lot of time in jail, and then you're not going to have your dog, you're not going to have your work, you're not going to have Cleophas. It doesn't matter. Probation is for a reason, and when you don't do probation, there are serious consequences. We issue warrants, put people in jail, bring them out in orange, and we have a hearing to determine whether you violated. And if you do, by testing positive, not doing your stuff on time, testing positive, you're looking at a ton of time. The other thing that you need to realize is that this DWI will be going on your record, and it's going to be there forever. You ever get pulled over in a car and an officer comes to you and they smell alcohol and they run your record and they see that you have a DWI, it's probably not going to go well for you. From now on, you're also facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no changing this. This is what you want to do. How do you plead to the offense, man? Guilty or not guilty?
Guilty.
I'll find you guilty. Do you know what happened on the ALR hearing? Can you run our license, please, Alex? What I'm trying to allude to is that I don't know what has happened with your license. I'm not going to suspend your license, but it's very possible that it got suspended through the administrative hearing versus DPS. If it did, your license and it is suspended, you're not allowed to drive. And that will also be a condition of your probation.
There's a current ALR suspension, Your Honor.
So your license is currently under suspension. You cannot drive. If you drove here, you can't drive home. It's suspended. Do you understand? So get the license back. Do you have children, ma'am?
No.
Okay. All right. Good luck to you.
Thank you.
Thank you.
Thank you, Your Honor.
All right. Coming up, gentlemen. All right. So who is Mr. Zion? Mr. Zion, you are wanted out of the state of Louisiana for felony carnal knowledge of a juvenile and misdemeanor sexual battery. Are you waiving formal extradition, sir? Mr. Dean. You were also wanted out of the state of Louisiana, you for second-degree murder, attempted second-degree murder as alleged. Are you also waiving formal extradition, sir? Okay, good luck, gentlemen. Thanks, guys. Yes, ma'am.
Judge, on that, you wanted them to pay the DPS fund as well, right?
No, wait.
Wait it, okay.
Yeah, wait. I usually waive on the first, on the second, then we got issue. All right, come on. I'm sorry to keep you
Was
waiting.
that just the DPS fund or all of them?
Okay, I'm
Judge,
sorry.
real quick, Mr. Wasserstein is here he's here on the trial case tomorrow.
Okay, let me just talk to her and then I'll hit Brenda up. Hi.
I have Miss Collins on docket today. She's set for bond forfeiture.
Collins.
Yes.
But she's the one that's in Galveston County. She's still in custody in Galveston County. She was not released. She won't, her next court date is on the 14th. I spoke with the state on an offer to hopefully take care of both. But I have to get possible PTI, but I have to get a mitigation packet together. She's been doing some classes in custody unprovoked. So I'll have to go to Galveston County, get those classes and get with her mom to get that mitigation packet to the state.
You're gonna go to Galveston County to get the stuff?
Well, I mean, I could ask her mom to go get it, but I'd rather.
Some serious out of court hours too. Does she have one or two cases? Just
She has one case.
So you got a PTI off on?
We don't have one yet. I need to get a mitigation packet together
Yes.
before they consider that.
And what, Mackenzie will consider it once she gets the mitigation material, but she needs the mitigation first. To even consider it.
What's she in jail for?
She's was on probation for theft in Galveston County, felony. Yes.
Yeah, that's all I see as well, Your Honor.
How long do you want?
Sorry, Doug? Can I, 2 weeks just to be able to?
Sure, of course. Yes.
All right, thank you. May I be excused? Thank you.
Okay, hold on. Let me get Brent.
Hey, Judge.
Hey, bud. How are you?
Good, good. How are you?
Just drama.
Judge, on the trial case tomorrow, we've reached an agreement. It's going to be a time served.
On which case?
Tate Garduno.
I think that we knew that, Ramona.
Yeah,
The
I
only case
approached
that
last
we're
week.
waiting on is Jones. Like, we knew Brent's case was gonna take care of, and then I think Blaze, we've got 3 trial cases. One's getting dismissed, one's pleading.
One, that was Brent's that you were planning on pleading, is that correct, Brent?
Yeah.
Yes.
Okay, and then the other one, Your Honor,
Jones.
I had to note that it's taken off the trial after he registered that off.
But now he has a bond violation.
Oh, understood. Didn't realize.
I'm ordering a panel just in case, and then we're gonna have a hearing again tomorrow. So just be ready, because now we've got bond violation of dudes out in the middle of the night, and like there are some other violations as well where he's like,
I get it.
okay, Brent. So
see you
you're
tomorrow
gonna come
morning.
in tomorrow then, take care of it?
Yes, Your Honor. We'll be there tomorrow morning.
Okay, thanks, bud.
All right. Thank you. Have a great day, everybody.
Hey, did you get anything back on Roberson? It's Brock's case.
On Robertson? No, Your Honor, not.
Oh, wait,
I think we're just waiting on an approval or denial, right?
Right. Brent Gomes just sent a follow-up email to Ashley Geis and still waiting a response from what I see.
so, Judge Geis, I believe you has denied the PTI request.
Denied.
Yes, sir.
Denied, Brock.
Yeah, actually, PTI. Yeah, I got that email already. I just need to see if the state can give me some other offer. And I need to see if I get a reset from Ms. Roberson so we can go with that offer and do a plea
Yeah.
or set up a trial.
Yeah, we'll give you a week, Brock.
That's fine, Your Honor. And I'll
And Brock, just stay offline. I'll talk about it.
And then are you good on the 24th, next Monday?
email you. Thank you, Richard.
Say
Thank you,
again?
John. My excuse. Excuse, I'll email Richard.
Say it again, I didn't hear you.
I said, thank you, Your Honor. I said, may I be excused? I'll
Oh,
get those
no,
offers
are you
from
good for
Richard.
next Monday for the court date?
That should be fine. I prefer the Monday hours every time she comes. Well, we could do the 30.
Ah, dog. It sounds like you're at a drive-through, man. Chat me what day you want next year, or not, I mean, next week. Oh, no, no. Give me a second. Come on.
I'm a plea, Daniel Torres, Your Honor.
Okay, let me just, put me to the side real quick, will you? So Torres,
What's the response, 224?
I don't know, I just chatted him. Okay. Speak with her. All right, good morning, Mr. Torres. Sir, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 1 year in Harris County Jail to be probated for 15 months. You will do a repeat offender DWI education class, 2 victim impact panels. You must also do a TRAS to see what other conditions you may need. You must fulfill all those conditions. If you don't, then into jail you will go. We will have a hearing. You will be facing a year in jail. You must do a TRAS, no drugs, no alcohol, guardian interlock, and 25 hours of community service. Is this how you understand the agreement, sir? You are giving up to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, there's no turning around. What happens on the next one? What happens?
Jail time.
No.
Enhanced, yeah, felony.
Prison time. 2 to 10 in the penitentiary is what you will be facing if you ever pick up another DWI. If I were you, even a sip of alcohol, I wouldn't get into a car. You need to understand that this is big business in Texas. And now there is also a surcharge that you will be required to pay because of this. Is it true or untrue that is a 0.15 or above? True the enhancement. You will be required to pay the $4,500 surcharge plus court costs that will be assessed in this case. And I'm going to tell you now, if you don't, every $100 that you owe, you will sit 1 day in jail. Do you understand?
Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you are stuck with this. You can never change this. You understand?
Yes, sir.
Is this what you want to do?
Yes, Your Honor.
How do you plead to the offer? Or how do you plead to the agreement?
You have to.
What does he have now? Does he have a guardian in law?
Yes, he does, Your Honor.
I'm going to find you guilty. I will send you to the agreements. Good luck to you, sir.
Yeah.
Thanks, sir. Aaron. Yeah. I'll hit you up next. I'll do it next.
You get the case number?
No, I think
Okay.
it's over.
I had it open, then I was like, maybe she has it. It's 2522-036. Okay.
Hey, Mr. Messina.
Señor Lucina, buenos días.
Mr. Messina, you were
Señor Mess-
charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they are offering you 45 days in jail with credit for the 15 days that you have done.
¿Qué ya se río?
You need to understand that there is an affirmative finding of family violence in this case. What that means is that you can never own a gun or ammunition as a result of this case.
De fuego por este caso. Okay.
Also, if you ever pick up another one of these cases again, you will be facing a 3rd-degree felony. A minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand?
¿Lo entiende? I understand.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
Bajo las leyes federales. I'm a citizen.
you give up the right to appeal.
a una apelación.
Once you accept this agreement, you're stuck with this. It will go on your record. It will be there for the rest of your life.
Y por todo su vida.
And then you,
Understood.
knowing this, do you still want to go through with this plea?
Sabiendo todo, ¿quieres seguir con esta declaración? Yes.
How do you plead to
¿Cómo
the
te
offense
declaras
of
a la
assault of
ofensa?
a family
Mi
member?
propia
Guilty or not guilty?
Guilty.
I will find you
Voy a
guilty.
hallarlo culpable.
I will sentence you to the agreement. Does this take care of the case upstairs? As a result of you pleading guilty to this offense, the injury to the elderly that you have, the felony case is going to get dismissed. I will tell you now, there's not many times that agreements like this will be offered. So if you are a person that has lack of self.
What? Wait, what? They had him plead to a misdemeanor so the felony gets dismissed? That's crazy.
Self-control issues. Find another way to deal with the aggression. People, children, that's not the right way. All right. Good luck to you, sir. Thank you, Mrs. Saldana. Okay, are you ready, Ms. Strong? So let me come up. So let me get this straight. You plead guilty last week to a terroristic threat. I told you as part of that not to go back to the location. The day after you get out, you go back to this location, you pick up a violation of protective order, and now you want me to take a time served? Really?
Sorry to interrupt. It's not a time
Yeah.
served. It's a 1 year in Harris County Jail. That's the maximum sentence. And I spoke to the complainant. That's what she's requesting. And
Okay.
Yeah.
But first, I would like to have him TRASed because I want to know how to go forward. Because the problem is that this has now become a revolving door where it's in and out and over and over and over. We need to figure out why. And the fact that you just keep going to jail over and over and over, why? Let's get to the root of the problem to figure out why. Why do we have these aggressions? Why do we have you keep coming back? That's what I'd like to do. Enough of this, So please, I'd like to set it for TRAS to see how we go forward to figure out so we stop. I mean, literally, Mr. Lopez, and I did this with you last week.
I understand, Judge.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. No. The time has come to stop. Okay, thanks. We'll try to get it done as quick as possible. I'll expedite you because you're in custody. Just be honest with these people. They're going to come evaluate you. Be honest with them. If I get the report back and it says that they're little bunnies jumping in the woods, that there's no issues, I'm going to send you right back to do it again because it's just not true. Okay, thanks. All right.
Your Honor, I am here on Miss Jessica Sanford. We had Miss Jessica Sanford here on an assault case. She picked up a felony PCS, Judge.
Ms. Sanford.
John, you're going to have to rewind it to watch the dog case that I put on. They bought a dog online. Nothing bad happens to the dog. The dog's fine.
You can't come to court like that no more.
Did you think you were coming to the club today?
No, sir.
This is a courthouse.
Yes, sir.
I don't see a disco ball, man. For real.
I just got
Don't come like this again.
Yes, sir.
I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. And I want to send you for a test now.
Yes, sir.
I want to know what, if anything, that you're going to test. And if I find that you pick up any new cases, I'm going to go absolutely bonkers on your bond. Do you understand me?
Yes, sir.
I'd like to send her for the test now and have her come back.
Yes, sir.
Judge, also she spelled on her second no show for copy. She spelled to appear twice.
I've called them the day of,
And they've rescheduled it for April the 14th.
Can you verify it? Can you
Because-
verify that?
Yes, sir.
We'll now make that a condition as well. Okay,
I'll send an email.
please. Okay, Mr. D, or John D, come on.
Judge, I am approaching you on Ms. Crawford.
Okay.
And there are two things, Judge. There was a BVR notice sent a few weeks ago and she
here?
Yes, she's there, Judge. She's in the, you want to bring her up or do you want me to just? It was for a.
Sent her for a test as well. She failed to go for one.
Right. Judge, just want to let you know that she didn't have transportation. Her car broke down, but she went right back the following day to try to do it. And it's all documented. She emailed me and all that stuff. I mean, text me. No, right. So I told her that. And so she did try. It's my.
Come up, ma'am.
She was sent for a drug test already.
Okay.
For Crawford?
Yeah.
It's negative drug test, Judge. So.
Thank you for testing negative. Good job. The next time you miss, don't.
Yeah.
You have a lawyer. We've given you a lawyer. If there's ever any issues, reach out to him and he can help you out. If they call you again and you miss again, it's not going to go well. Okay? All right.
Judge, the other thing I want to let you know is she is like, PTI bound. We had a miscommunication because she sent me her application, but it went into my junk mail. So I never got it, but I found it today. We just need a little bit of time for me to forward that and not do that.
Yeah, you got it. Okay.
Thank you, Judge.
For application?
Yes.
We can do it. Go ahead.
Well, I've got the application.
No,
It's done.
Oh, it's done.
I need
It's
to,
not submitted.
right.
Okay. Guys, you ready? Thanks for being patient.
Yes.
It's going well, Judge. Tell me something nice.
Yeah, Judge. We're here on Disaki, Dissake.
Okay.
He's getting us mitigation, Judge. He's in good contact.
No, you've had it till December. He doesn't have it done still?
He's gotten some things in.
Please, is it yes or no?
To me today. No, Judge.
And I'm rolling it to tomorrow. And I'm gonna roll it every single day until he gets it done.
The only thing I asked, Judge, is I'm out of county tomorrow. Can we just at least
Zoom.
Can we do it Wednesday? But it's not a.
He's gotta be here. You can Zoom.
Okay.
I have Zoom for you. But since December, we're
Yes,
now in March 17th. You want a back rub too?
I can.
Really? Not you.
I can't make him.
No,
Judge.
so he's coming back tomorrow and every single day until he gets it done. Okay.
Let him know. Thank you, Judge.
I love you, man. All right, ready?
So reapproaching on Mr. Gonzalez, Judge.
Okay.
Two things going on. Initially, Ashley denied him because she said that he had no insurance.
No insurance at the time.
She said according to a police report, he had no insurance and he got into an accident. That's why I'm denying it. I talked to my client. He did have insurance on that day. And the insurance company tried to get a hold of the CW, was unable to. I emailed Ashley this morning a copy of his insurance and a copy of the response from Geico saying.
Okay. So why don't we just set it for a couple days to see if she'll.
See if she responds.
And.
That's fine.
Monday, Wednesday?
Yes, and the reason why I waited to now, because I was hoping she'd respond. I sent it to her about an hour and a half ago.
We'll set it 2 days and give you, hopefully that's enough.
Okay,
for her to-
is it okay if I waive my guy's appearance? Because he comes every time.
But if she still denies it, we gotta set him for later in the week so we do something.
Perfect, sounds good. Thank you, Judge.
You have an arraignment. You have an arraignment. Oh,
Right?
okay, let me get. Marcos.
Yes.
Okay, that's it. Want to make sure. Counsel, come on. Hi.
Judge, I've got an off-docket matter asking the court to set bond on a case, please.
What's your cause number?
It's going to be Jaden Bolding. His cause number is 255-4634. 255-4634.
Okay, give me a second. Let me make sure everybody
Yes, sir.
gets it. You got it?
Yes.
Jim? No. 255. 4634.
255-4634. Yes, sir.
34. No, 4634.
Okay.
Okay, you want to bring your client?
Yes, sir.
I'm sorry, what was that case number?
255-4634. It's an off-docket arraignment.
We need a PSR on that one.
Yeah. Good morning, sir. Give me one second. Did you hear that?
Yes, I got it, but I haven't done the PSR.
Take it down. All right, good morning, Mr. Bowling.
Good morning, Your Honor.
Mr. Bowling, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 7th, 2025, in Harris County, Texas, officers were dispatched to a mental health call and met with the witness and the complainant, who are the stepfather and mother of the defendant. The witness stated that the defendant suffered from an undiagnosed mental illness, which caused him to get triggered. The defendant was triggered by clothes lying on the bed and started to argue. The defendant grabbed a pair of scissors, which the complainant took from him before the defendant struck the complainant several times, causing pain. I'm sorry?
Struck who?
The complainant.
I know. Who is
Stepfather, Your Honor. The stepfather.
All right, Mr. Bowling, I'm going to find that there's sufficient probable cause to go forward with your case. I am now entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Mr. Lawson as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior. You cannot be in possession of.
I know he says this stuff every single day, but he doesn't read this. The judges that we see, they have it all memorized that they say this exact thing every day, but it's still a lot. It's a lot to say every day.
Weapon. This usually comes with a residential restriction. We need to figure out, are they here?
They're not, but the state has
Your Honor,
conferred.
We have spoke with them and the complainant does want the defendant back at the residence.
And we'll take off the residential restriction.
Thank you.
How old are you, sir?
I'm 27.
You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. And I'm telling you now that I'm going to test you for marijuana. If I find that you're using, it's not going to go well for you. Do you understand me?
Yes, sir.
I promise you, you're going to get tested. If I find that you're using, I will revoke your bond, put you in jail, no more PR bonds. I'm going to give you a PR bond today so that you don't go to jail. But if I find that you become a danger to my community, I will do everything in my power to protect every single person. I don't care what your excuse is. I don't care what you're going through. If there are issues, now is the time for you to take care of them. I hope that this is enough of a wake-up call that I don't have to put you in custody, because we have enough people in there now as it is. What do you do with yourself?
Yes, sir.
Are you in school? What do you do?
I'm planning on going back to college, sir. But
I use the same jokes over and over and over again at all my tables, and I don't mess them up.
cut hair and I produce and I engineer music, sir.
Okay. Let's work at HEB. You graduate from high
Oh,
school.
and I work at HEB. Sorry, that was HEB is like my job, but it's in career.
High school. Did you finish high school?
Yes, sir. I graduated.
It's time for you now to also start thinking of the future. You know, the more education you get, the more money you're going to make in life. And I'm going to tell you, this life is so great if you have money, and it's so terribly awful when you don't. I promise you. The farther you go, the more knowledge you get, because knowledge is power. This is what you're going to get. This is not good. Now you have a lawyer. Have you signed on yet?
I will today, Judge.
I need you to sign on. I have attorney of records in the tower. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you got to stay in touch with him, and he'll tell you if and when you have to come back. You're going to get tested. Don't use. You understand?
So
okay. Guys, bond. Any recommendation?
We would ask for maybe a $500 surety bond. Not anything.
Do you have any priors?
Yes, no priors. No priors, Your Honor. And due to the mental health concern of the case, we wouldn't
Surety bond's gonna do what?
I spoke to the DVD prosecutor as well, and that's what he conveyed.
Well, I'm gonna give you a PR bond. I'll set your bond at $100.
Thank you. Your Honor.
Just make me proud. That's all I'm asking you to do, man.
Sure.
All right, guys. We made it. Thank you so much for coming out today. I really, really appreciate it. Thank you, mods, for all your hard work today. The hostess don't insult you. They get paid to not insult you. It's hard sometimes not insulting some of the people, but we don't insult them. We take care of them. Thanks for coming out. I'll see like 15 of you maybe in OJ. That starts. Oh, I'm gonna make it so that it automatically goes over. If I could figure out how to work this computer. Tech today is really, really not on my side. It's just not. But that's okay. Maybe when I get to work, the computers won't work either, and that'll be great. That'll be a fun double. I'm just fixing this, and then I'll stop. Redirect, OJ, save. There we go. I'll see 15 of you in 2 minutes. Thanks, guys. Bye.